So I heard Ms. Harrington make 2 points with respect to that point. One was that it's different when the district court does it on the merits and has asserted jurisdiction over the suit when that decision happens. And the second is that if we applied the same rule here, we would have a real problem with any fraudulent joinder case because you could never say that at the time of judgment there was, in fact, jurisdiction.
Your Honor, if I may, I'll speak to the second point first. And I think that that's just a false understanding of fraudulent joinder doctrine, and there's no principal way to draw the distinction that the petitioners are trying to draw. And I would call the Court's attention to 2 of your decisions that I think illustrate the point that I've made, which is that when a party is found to have been fraudulently joined by a district court, its citizenship is disregarded, but it doesn't cease to be a party to the litigation. That remains subject to appellate review. So 2 cases the Court should consider. The first is the kettle hockey case, which is discussed in our brief. That's one of the cases from the voluntary-involuntary line of authority. And in that case, the state court not only found that there was no viable claim against the non-diverse defendant, but under state procedure ordered a involuntary non-suit, and so separated formally that party from the litigation. And this court held, when the question reached this court, that that involuntary non-suit did not so terminate the party's significance from the case that it resolved a jurisdictional issue. The second case that I would call to the Court's attention, which isn't discussed in the briefing, is Mecom versus Fitzsimmons. It's 284 U.S. 183, a 1931 decision by this Court, in which this Court reversed a fraudulent joinder ruling. And the necessary premise of that is that that party remained in the case until it arrived here for this Court to reverse the ruling. The party didn't disappear immediately. As a practical matter, Whole Foods has been in this case from day one. They are here today. Their counsel is sitting here at counsel table because they are a party to this litigation. You can't pretend otherwise.
That was one of Justice Kagan's points. Was there another one?
Your Honor, I think the first point was that there's a distinction to be drawn between a merits-based disposition and a jurisdictional disposition. I don't know that that's a stable distinction in principle, but certainly when you're dealing with fraudulent joinder, for which the question is whether there's a reasonable basis for the claim, the substance of the analysis merges. And so a federal district court's interlocutory determination to dismiss a federal question claim has the same consequence as its interlocutory determination that there's fraudulent joinder. The party still remains in the litigation subject to appellate review, and therefore the jurisdictional issue is not cured.